Every day we get closer and closer and closer to seating a jury in Massachusetts for defendant Karen Read. She's in court today for day 4 of jury selection. And so far there have been 10 jurors that have been seated. Now right now the jury is made up of 5 men and 5 women. The court plans to seat between 16 and 18 jurors. The goal is to get a deliberating jury of 12 and then at least around 4 alternates. Now as jury selection moves forward, Karen Read's defense team is asking for something new, but it is expected. They are taking things to the highest court in the land, the U.S. Supreme Court. They're asking the justices to step in before her retrial begins and arguing that this trial is double jeopardy. It's in a filing that happened Thursday night. Read's lawyers asking the Supreme Court to consider, quote, a unanimous but unannounced decision by a jury following trial that the prosecution failed to prove a defendant guilty. Keep in mind, lower courts have rejected this request to dismiss the charges. The top charge of second-degree murder and the lower charge of leaving the scene that the defense says the jury and jurors confirm that behind closed doors they agreed on those charges but never wrote it down and never told the court. A key figure in Read's trial is Judge Beverly Cannone. Here's Court TV anchor Judge Ashley Wilcott with a look at her honor.
We have been unable to reach a unanimous verdict.
After declaring a mistrial in Karen Read's first murder trial last year, Judge Beverly J. Cannone is presiding over Read's retrial.
This is funny, Ms. Read?
Cannone, a Boston South Shore native, was appointed a district court judge in 2009 and a superior court judge in 2014.
She comes to this from a defense perspective. That she used to be a public defender, and in fact, her father was a public defender.
Judge Cannone has had a remarkable reputation as a criminal defense attorney, essentially a superstar criminal defense attorney.
A 25-year career, in fact, defending clients like Read, accused of murder and other violent crimes. In 2002, Cannone was named Justice Defender of the Year.
I believe she really does stay above the fray and is not going to be swayed either way, and is going to make her decision based on the best interest of judgment.
She gets a lot of criticism in both directions, and quite frankly, if both the prosecution and the defense are criticizing you, you're probably playing it down the middle. But thus far, even at the appellate level, her rulings have been held up.
Still, Read's defense team asked Judge Cannone to step down before the first trial over a social media post alleging the judge knew some of the state's witnesses.
I want to make it very clear that I reject the notion that untrue and unsubstantiated rumors spread on the internet can force a judge to recuse herself. I know full well the importance of a fair and impartial judge. And I know full well how to follow my oath and comply with my ethical obligations. All 4 points raised in the defendant's motion are without merit. Your motion is denied.
As protesters rally in support of Karen Read's innocence outside of court, Judge Cannone is focused on what's happening inside the courtroom.
She does keep a good, responsible hand in things to make sure that things are moving along, that there aren't unnecessary delays. In a case like this with such complexity, it really could go on and on and on.
Ultimately, the people who matter in this case are the people who sit in the jury box. What she needs to do is ensure that they are not tainted by the spectacle. Ultimately, you're talking about a case that's going to be tried in a relatively small courtroom to a relatively small number of people, and it's going to have, a million eyes on it.
While trial attorney Michael Jafer, who is with us to talk about the Karen Read case. And Michael, I feel like I need to have a little asterisk by your name when you talk about the Karen Read case because you are very pro-prosecution in this case, though we know your opinions are grounded in facts and the law. But tell me what you think about this request to the U.S. Supreme Court and this notion of there being a unanimous but unannounced verdict. I mean, if this was taken up, this would be big when it comes to what happens in the deliberation room and whether or not it could actually impact the outcome of a trial.
Here's my opinion on it. I think it's garbage. I think it's grandstanding. I think it strains credulity to even think that. I really, really believe this is grandstanding. By the way, I want to be clear. If I was her defense attorneys, I'd be doing the same exact thing because I would want to take advantage of the spotlight in hopes that some jurors potentially will see this, because there's no such thing as pure jury sequestration. All the jurors that are going to be the jurors in this case are going to know about this case. Everybody in the country knows about this case. You can ask a barista and she'll know about this case. I think this is garbage. The thought that Judge Beverly Cannone sent you back to the jury room several times, you first jury, and each time you guys came back and told her, we are hopelessly deadlocked. The jury floor, Judge Beverly Cannone wasn't in the room with you. She wasn't taking notes. She didn't tell you that you're deadlocked. You told her that you're deadlocked. You specifically told her, we are hopelessly deadlocked. You used adjectives to Judge Beverly Cannone, begging her not to send you back into the room. I'm offended by this. I feel insulted. My intelligence is insulted. And I absolutely detest this thread, this line of logic, because in my opinion, this is to the jurors, you're either the dumbest people or one of you is lying. And I don't think it's the first thing. I think someone is lying. There is no way that Judge Beverly Cannone sent you back multiple times, and multiple times you told her we are hopelessly deadlocked, but you were unanimous on the top charge. It makes no sense. What are we doing here? This is completely farcical. There is just no way that happened. One more thing. How could you be unanimous on the first charge and third charge, but not be on the second charge? It sounds to me like somebody's just lying.
Oh, Michael, it's not just one juror that's saying that. There have been several jurors who have come forward. I believe at this point it's the majority of those 12 who have come forward to at least the defense, the media, or to the prosecution to say, yeah, we were unanimous on not guilty. I agree with you. It's very weird that they at least didn't ask the judge, because I have seen that. I've seen jurors not know that they can bring back a partial verdict, but they will ask the judge, what if we're hung on one charge and not on the other? We'll see if this even gets reviewed by the Supreme Court in the amount of time, but the odds are that it is not, and we are going forward with this trial. But in talking about the jury, we've had some viewer questions about sequestration. You mentioned there's no pure sequestration, but why do you think these sides haven't asked for any kind of sequestration, even a partial? Once the verdict, or once the jury is deliberating, they could just have them sequestered for that point in time.
I think the day and age that we live in, right? If you walk past that courthouse, your phone identifies that you're there, and it feeds you stories, and you start ingesting stories about it. I think it's just the law has not caught up. These sequestration rules were set up in a time before social. They were set up until 10 years ago, 15 years ago. They work. They just don't work. I think the system's trying to catch up. I think at this point, if you're like Hank Brennan, for example, all you can hope for is you have a jury pool that does not have people who believe the earth is flat, complete morons, because that's what you need in order to believe the Karen Read defense Bigfoot theory, right? That's what you need to believe it. So I think you just hope that, hey, we're not going to sequester these people. There's nothing we can do about it. Let's just hope that they're not complete morons. And after the first trial, a tear-soaked friend of John O'Keefe said that during the over 27 hours of jury deliberation, they kept hearing "Free Karen Read," that silly chant, in their ears. So I think all they can hope for now is just to keep the public away and just hope for the best for the train wreck. So that's why I think that, Julia.
Michael Jafer, thank you for your analysis.